Thanks again for joining us. Welcome to Clark's Legal's seminar covering issues to do with PI insurance generally and also specifically the Insurance Act 2015. We're also going to cover various aspects of D&O liabilities. Our team today is myself, so John Weevil, one of the partners here at Clark's Legal. We've also got Victoria Kempthorne, who's one of our associates here, Stanley Kamalu, trainee solicitor, and Stephen James, who's one of our partners specialising in the dispute resolution side of things. I'm obliged to tell you that if you have any questions as we're going on, type any questions you have into the questions drop-down box on your dashboard, and we're going to answer as many of those as possible at the end of the webinar. So the agenda is PI insurance generally, recent case law roundup, which Stanley's going to do, Insurance Act 2015, which is my one, and Stephen is going to finish off talking about D&O liability. And to get us going, I'm going to hand over to Victoria, who's going to cover PI insurance basics and expanding on that to go into some more detail about the key provisions of PI insurance policies.
So I'm going to be providing an overview of professional indemnity insurance, and we'll consider why a consultant needs professional indemnity insurance, the extent of cover it provides, an overview of the provisions in a typical professional indemnity insurance policy, and also how to maximise insurance recoveries under a PI policy. So, what is professional indemnity insurance? There are many ways in which a consultant can manage the risks which could arise in providing their services. So, for example, carrying out due diligence in respect of new clients, keeping up to date by attending training courses, and also negotiating appointment terms to include limitations on liability. Professional indemnity insurance is another risk management tool and will provide protection for a consultant when all risk management procedures have failed to prevent a claim arising against a consultant. So professional indemnity insurance provides cover against claims for negligence. If a consultant is alleged to have provided inadequate advice, services or design to a client, then subject to the terms of the PI policy, professional indemnity insurance will provide cover for the legal costs and expenses of defending the claim, as well as compensation payable, and that's up to a specified sum, to the client to rectify the mistake, providing negligence is proven to have been committed by the consultant. Very few companies will have sufficient resources to meet claims brought against them in respect of professional negligence. So it is important that consultants and also contractors working on design and build projects take out and maintain adequate professional indemnity insurance. So maintaining a specific amount of insurance cover is also a common requirement of consultancy appointments and building contracts. Almost every client will expect a consultant to have professional indemnity insurance at a level which reflects the project value and also the risk of the consultant's services. So it's worth noting that there is no such thing as a standard insurance policy wording, as precise wording will differ from insurer to insurer. However, there are some key phrases which are used, and PI policies also tend to cover similar issues. So on the slides is a typical insuring clause. To activate this PI policy, the claim must relate to a breach of professional duty, and so this narrows the focus of the insurance cover to professional negligence, and also the breach must have occurred during the course of the insured's professional business. It's worth noting the definition of professional business, which may be narrowly defined, so a consultant only engages in business activities that are within the reasonable scope of its professional competence. So in order to recover under a professional indemnity insurance policy, the insured must establish the existence of an actual legal liability and also ascertain its amount. To become a legal liability, the consultant must have been found liable to pay damages by a court or other competent forum. Legal liabilities resulting from negligence or breach of contract can include claims for property damage, personal injury, consequential and economic loss, and also the cost of redesign and repair. The majority of professional indemnity insurance policies are written on a claims-made basis. This means that the insurer will indemnify the insured, and that's up to a certain amount, in respect of any claims which are made against the insured during the policy period, and that policy period is usually taken out annually. Under a claims-made PI policy, it doesn't matter when the negligent act or omission occurred. If the insured is made aware of the claim or circumstances which might give rise to a claim, and then notifies the insurer during the current policy year, then cover should be available. Insured should bear this in mind when considering whether to cancel any PI policy. As claims can arise for years after a project has been completed, it's important for consultants to maintain professional indemnity insurance for as long as such risks exist. One thing consultants may want to consider is obtaining run-up cover for latent claims to be notified should they be claimed against the insured after cancellation of that policy. A PI policy will set out exclusions from the cover. So, for example, PI policies will usually include a carve-out for claims which arise out of or are related to circumstances already known by the insured at the start of the policy, but which are not disclosed to the insurer. Cover will usually be subject to an exclusion in the event that the insured was aware of an employee's dishonest act or could have been reasonably discovered the dishonesty. A PI policy will rarely indemnify a consultant for losses caused by its own fraud. Many PI policies include an express exclusion in respect of punitive damages, so for example liquidated damages. Performance warranty guarantees such as fitness for purpose or free from defect type obligations are often excluded from a PI policy. Consultants should be aware that their PI policy may not provide protection against claims all over the world, and many PI policies will often exclude cover for criminal fines or regulatory penalties. PI policies will also have exclusions to carve out liabilities which fall within the terms of other types of liability cover. So, for example, employers' liability policies, public liability policies, and also directors and officers type policies. Many PI policies will have a retroactive date, which acts as a cut-off for historical claims. So this is designed to prevent insurers from having to indemnify the insured in respect of claims brought during that policy period, which relate to events which may have occurred many years earlier. The inclusion of any retroactive date is something that a consultant should discuss with its broker, and this will ensure that there is no gap in cover for historical claims which may arise. Other provisions commonly found in PI policies include notification clauses, prohibitions against the insured settling claims or making admissions of liability without the insurer's consent, and also claims cooperation clauses requiring, for example, the insured to give such information and assistance to the insurer as it may reasonably require in the event of a claim. So the amount of cover provided under a PI policy is determined by the limit of indemnity, which will usually be set out in the schedule to the PI policy. The limit may be expressed to be on a per claim or per loss basis, which means that the limit will be available for each and every claim or loss as applicable, or also in the aggregate, which means the limit of indemnity will be available for all claims that fall for cover in that policy period. The excess will also be set out in the schedule to the policy and is the amount of any claim that will be paid by the insured. The insurer will only be liable to pay sums due under the policy over and above that amount. It's also common in a PI policy for there to be an aggregation provision. And so an aggregation provision means that two or more separate claims covered by the policy will be treated as one claim when they have a unifying common factor that links them together. So it's common to see limits expressed to be both on a per claim basis and also in the aggregate. So on the slides is an example of wording which will be contained in a professional indemnity insurance certificate. And so, for example, if the limit of indemnity was expressed to be £100,000 for each and every claim and £1 million in the aggregate, this would mean that there was a maximum limit of £100,000 available for each claim, but insurers would pay no more than £1 million in total for all the claims covered under that policy. It's also common for claims relating to pollution, contamination and asbestos to be subject to an aggregate limit. So it's important that consultants are aware of the notification provisions in their PI policies and also when their obligations to notify are triggered. So typically a PI policy will require an insured to notify of any circumstances which may give rise to a claim, and also any claim actually made against the insured. An insured will be required to disclose material facts to its insurers prior to the commencement of the policy or also at renewal. So as mentioned earlier, if no disclosure is made, the policy is at risk of being avoided if the non-disclosure subsequently comes to light. So it's really important for consultants to notify circumstances to insurers during the policy period to ensure cover. Future claims arising out of circumstances that have been validly notified will be deemed to have been made during the policy period in which the circumstances were notified, even if those claims do not materialise for many years. So in relation to notification of claims, a claim may be a defined term in the PI policy. And so on the slides, I've inserted a typical definition of a claim. A claim can be summarised as any demand for damages or compensation, an intention to commence legal proceedings, or notification of legal proceedings. And in summary, a couple of tips to take away with you so you can maximise insurance recoveries under a PI policy are: it's important for consultants to understand the key terms of its professional indemnity insurance policy. It's beneficial to have an effective claims reporting system in place. Consultants should understand the notification provisions of its PI policy, particularly in relation to timing. Consultants should also notify every circumstance which might give rise to a claim, and we would always recommend that the notification is put in writing. And consultants should assist the insurer in defending or settling the claim. In particular, consultants should not admit liability without the insurer's prior written consent. So Stanley will now talk about recent insurance case law.
So the insurance bill was granted royal assent earlier last year, and the insurance and wider industry have been busy organising to ensure it's well prepared for changes in UK contract insurance law before it comes into force in August 2016. However, it's very easy to forget that there's a wealth of cases that still continue to assert the common law position on insurance contract law. So therefore it's important to briefly highlight at this point some cases that govern areas of insurance contract law such as utmost good faith and disclosure. So today I'll be focusing on three main noteworthy cases that include Mutual Energy and Starr versus Starr Underwriting. So the meaning of deliberate non-disclosure was considered in the context of utmost good faith duty. Jones and Environcom, which clarified the broker's duty to clients to explain their disclosure obligations. And finally, Eurokey and Giles, which appear to reverse that trend of brokers' duties becoming more onerous with each reported case. So Mutual Energy and Starr Underwriting, unlike most commercial contracts, insurance contracts require an insured to act pre-contract in utmost good faith. So this is quite an onerous duty. So this requires the insured to disclose to the insurer any material facts that it's deemed to know about the risk to be insured to avoid making material representations about the risk. So it's very important to do this to allow the insurer to properly assess the risk and to fix the premium. So at this point I just want to note that under the 2016 Acts, every breach of utmost good faith will not lead to avoidance or automatic avoidance of the policy, but in this case the judge decided not to follow that principles of the 2015 Act and relied on the common law that was set out. So just to begin with a general factual background, So the insured owned and operated an undersea interconnector, and this interconnector was insured by insurers. Now the relevant terms of the policy were that Clause 5, the insurer acknowledged that they had received adequate information to evaluate the risk of insurance, and in Clause 6A, the insurers also agreed that the policy could only be avoided for reasons of non-disclosure where that non-disclosure had been either deliberate or fraudulent. So this was the exclusion clause. The insured, in this case, failed to disclose the persistent issues with the interconnector cable. So when in 2011 the insured made a claim under the policy, the insurer tried to rely on Clause 6A by alleging that the insured had deliberately failed to disclose that there had been problems with the interconnector's cables as opposed to the fraudulent. So it was the deliberate aspect that they relied on. So what the courts found in this case was in favour of the insured essentially. So the court determined that deliberate non-disclosure, as referred to in an exclusion clause in an insurance policy, had to involve a dishonest decision not to disclose. So in essence, an insured's decision not to disclose something as a result of an honest but mistaken belief that it did not need to be disclosed was not enough to allow the insured to avoid the policy. And just as a comment, I guess, it was the commercial decision, business sense, that the court felt that the insured should be punished if it had behaved dishonestly, but not if it had made an honest but deliberate mistake. So essentially, the fraudulent non-disclosure, or deliberate, as with fraudulent non-disclosure, deliberate non-disclosure would require an element of dishonesty. So on these facts, that was not the case. And the insurer's attempt to argue for a wide meaning of deliberate was restricted by the courts, meaning that in practice, an insurer claiming such deliberate non-disclosure will need to establish something very close to fraud, which is in fact difficult to do in the absence of very clear evidence. So in the second case that I'll be considering today, is Jones and Environcom, where it was further illustrated or considered the broker's duty to warn. So in this case, the insured, Environcom, operated an electrical goods waste facility and used plasma cutters at high temperatures to remove difficult bolts from refrigerators that contained extremely flammable substances. So the insured failed to report several previous smaller fires or the use of plasma cutters, and in 2007 they claimed from the insurer for a fire that destroyed the business premises, and the source of ignition was likely those plasma cutters that were not disclosed to the insurer. So the consequence of this was that the insurer rejected a claim on the grounds of non-disclosure of the earlier fires and also the use of the plasma cutter, meaning that the insured settled with the insurer for $950,000 and then pursued its broker, who negotiated the deal for the £6 million shortfall on the grounds that they negligently failed to advise them of their disclosure obligation and made insufficient inquiries to discover previous fires and the use of the plasma cutter. The courts interestingly found that in this case the key finding was that a broker had to satisfy itself that the client understood the need of their disclosure obligation to the insurer. So this usually required a specific oral and written exchange on the matter, both at the time of the original policy being provided and at the time of its renewal. So the broker could not just rely on written standard form explanations that disclosure obligations had been properly explained. So in essence, the court established these principles whereby the broker must firstly advise their client of their duty to disclose all material circumstances. They must explain the consequences of failure to disclose, and they must indicate the source of matters that ought to be disclosed as being material or arguably material. And finally, they must take reasonable care to elicit matters which clients ought to disclose but might not consider necessary to mention. So this principle to be borne in mind. In the final case I'll be considering, Eurokey and Giles, this case represented a turn of the tide, so where the courts reversed the trend of brokers' duties becoming more onerous for each reported case. It involved another fire, and the general facts of this is that the broker, Giles, placed an insurance cover for the insured Eurokey in respect of the insured's waste recycling plants. Now the cover included business interruption and was obtained on the basis of the turnover of 11 million. In reality, it was the turnover of the insured was actually 17.6 million, meaning that the business interruption cover should have been higher. In these circumstances, the insured was severely underinsured, and when a fire occurred, the insured obtained a low settlement with its insurer. So the familiar scenario occurred where Eurokey, the insured, tried to recover the shortfall in negligence against the broker. The court dismissed this claim against the broker entirely, as the broker cannot be expected to conduct a detailed investigation into the client's business. Now, the court still reiterated the principle that should guide the broker, namely that the broker must still take reasonable steps to ascertain the nature of the client's business and of their insurance needs. So, in summary, the duty on the broker is quite high, but an insured cannot work on the assumption that the broker will understand the client's business for insurance purposes. And in this case, the broker had adequately explained business interruption cover and had no reason to believe that the figures provided were inadequate or when they were advising on the levels of cover. So just generally, some points to guide are that the sophistication of the client is important. So this again is case specific. So it can't be assumed that a small or medium-sized enterprise will have any understanding of insurance. As we know, in this case, the broker was considered to have given sufficient guidance. The burden is on the broker to demonstrate what advice has been given. And finally, the broker is not expected to verify information provided by a well-informed client unless he has reason to believe it's not accurate. So I guess the principle is that you should ensure that you provide enough information to the broker. So just to conclude, there remains a variety of detailed and authoritative cases, wealth of case law that asserts the common law position on insurance contract law, and therefore against the backdrop of the Insurance Act 2015, insured insurers, brokers alike should all be minded not to forget the common law background that exists, and that should indeed continue to be a guiding force toward parties. So with that, I'll pass on to John Weaver, who will then now consider the Insurance Act 2015.
Brilliant, thank you, Stanley. This is me again. So as Stanley said, I'm going to cover the Insurance Act 2015. This is kind of necessarily just scratching the surface because in the 10-minute talk it's hard to get into that real detail of an act as potentially changing to the scene of insurance as the Insurance Act 2015, but I'm going to give it a go. And if you've got any questions, then please do either go online and let us know during the course of this talk, or offline you can always drop us an email and we'll do our best to respond. So the Insurance Act 2015 comes into force later on this year, so on the 12th of August 2016. And it is said to represent the greatest change to insurance contract law in over 100 years. Basically, the aim is to place insurance law in a position that's more favourable to the insured. Application of the Act, so it applies to all of the countries in the UK at the moment, and it doesn't apply retrospectively, so it's only going to apply to contracts of insurance entered into on or after the 12th of August, and to variations agreed on or after that date. So it is not going to be in any sense retrospective. So it's worth noting that with a couple of important exceptions. So the key one, I think, is Section 9 basis clauses. The Insurance Act sets out the default regime only. So insurers are able to contract out of various important provisions in dealings with non-consumers, provided, of course, that the contracting out is done in a transparent manner. And what constitutes transparent is insurers have to take sufficient steps to draw disadvantageous terms to the attention of the insured. So if they're excluding something, they have to draw that to the insured's attention, and they have to kind of let them know what the exclusion is going to mean for them in practice. So disadvantageous terms have to be clear and unambiguous as to their effect according to Section 17 of the Act. And that suggests to me that blanket exclusions are going to be ineffective. So any exclusions proposed by insurers are going to have to be very specific about what they're excluding and what the effects on the insured are going to be. So I think this is a key watch point for insurers and those who draft PI policies for them. So what are the most important provisions of the 2015 Insurance Act? I've broken these down into three main categories. So first key provisions concern utmost good faith and non-disclosure. And these changes apply to business insurance only, so consumer insurer relations are dealt with under CIDRA from 2012. So the basic rule is that business insureds have to make a fair presentation of the risk to their insurers. Now I know this is going to represent a bit of a change in the landscape for insurers and also for insureds, but I think that the provisions of the Act represent much needed clarity about what information an insured has to provide, and also who's responsible for putting that information together. So why is a fair presentation of risk required? Well, this provision is aimed at preventing data dumping. So Section 3 sets out what a fair presentation is, and the basic rule is that fair presentation equals making the disclosure in a manner which should be reasonably clear and accessible to a prudent insurer. So not just dumping all of the files in relation to a particular entity and asking the insurer to sort out the wheat from the chaff. It's all about being very specific about the details that an insurer would want to know about a risk in order to fairly assess what premium they need to charge. And related to this is the requirement for a fair disclosure as well. So the disclosure required is disclosure of every material circumstance of which the insured knows or ought to know. Or put another way, it's disclosure sufficient to put a prudent insurer on notice that they need to make further inquiries for the purpose of revealing those material circumstances. So it's all about giving an insurer enough information so that they know what they don't know, if that makes sense. And the question might arise, who needs to know what? So within the insured entity, who needs to know what? And in deciding what an insured knows, the Act says that what matters is the knowledge of the senior management within that insured entity. So an insured has to carry out a reasonable search for information, and what's reasonable is going to depend on the size and complexity of the insured's business. The insured is deemed to know what should reasonably have been revealed by reasonable search of the information available. So the Act does provide additional disclosure requirements and additional requirements on an insured to do a trawl for information in order to make a fair presentation of risk. But on the plus side for insureds, the Act is also providing much needed clarity about what they need to do and much needed clarity about whose state of mind is the key component in an insured's disclosure obligations. And it's worth bearing in mind as well that it's not all one way. So the fourth bullet point there makes clear that the Act creates a positive duty of inquiry on the insurer as well. So it's not all one-way traffic. So the second set of key provisions revolve around remedies. The remedies for material non-disclosure or misrepresentation are going to change. So if the misrepresentation or non-disclosure was deliberate or reckless, then the insurer may still avoid the policy and keep the premium, potentially. But in all other cases, a scheme of proportionate remedies applies. I'm just going to go through those tiered proportionate remedies one by one. So the first tier, if the insurer wouldn't have entered into the contract of insurance at all, and it should be noted that this is a subjective test, so this is about what this particular insurer would have done in these circumstances. So if the insurer wouldn't have entered into the contract at all, but for the insured's breach, then the insurer may avoid the policy and refuse all claims, but they have to return the premiums paid. And you might say that's not very fair, having a subjective test. So how is the insured meant to disprove what the insurer would subjectively have said that they would have done? And yeah, that's absolutely right. It is quite a difficult test for the insured to disprove. But I think the reason why this test has to be subjective is because the Insurance Act has taken away the insurer's silver bullet. So before, they could have just denied any liability under the insurance contract altogether. And in the new regime, there are going to be these tiered remedies, and I think it's only fair that the insurer has to be taken to mean what they say in circumstances where there has been a breach on the part of the insured. So second tier of remedies, if the insurer would have entered into the contract of insurance but on different terms, and that is different terms other than terms relating to the premium, then the insurance contract has to be treated as if it had been entered into on those different terms, if the insurer so requires. And for the purposes of the Act, it doesn't matter if the insured wouldn't have accepted those terms. If the insurer says that it would only have entered into the contract at all on different terms, then those are the terms that will apply if the insurer requires that. And the third tier of proportionate remedies is where it gets a bit more tricky. So if the insurer would have entered into the contract but would have charged a higher premium, and this is irrespective of whether the other terms would have been the same or different, then the insurer may reduce the amount paid on the claim proportionately. So I've set that out diagrammatically. So X percent, so X there representing the percentage of the claim that the insurer actually has to pay under the terms of the new Act, is calculated by taking the premium they did actually charge and dividing that by the higher premium that they would have charged, and then multiplying the result by 100. The third set of key provisions concerns warranties and other terms. So the current law is that a breach of a warranty in an insurance contract automatically discharges the insurer's liability completely from that point onwards. And that's the case even if the breach is remedied. It's also the case even if the breach is entirely unrelated to the type of loss that occurred. So the paradigm example is, for example, warranty in an insurance contract that the insured is going to maintain a working burglar alarm, and the type of risk that happens, the type of loss that is caused is flood damage. Well, in those circumstances, if the burglar alarm wasn't being maintained, then the insurer could deny liability for that risk. And this is all going to be swept away by the new Act. So here's the new regime. There's no automatic discharge. So breaches of warranty can be remedied by the insured, but cover under the policy is suspended during the period of the breach of warranty. So in the example I just gave, if somebody hasn't been maintaining their burglar alarm, but then they partway through the policy period start maintaining their burglar alarm, then at that point the breach of warranty has been remedied, and an insurer will potentially be liable for losses again that take place after that breach has been cured. I put in brackets if the breach can be cured, so there can be some breaches of warranty that can't be cured at all. So last 2 points on the new regime relating to warranties. So point number one, an insurer can't rely on an irrelevant warranty breach anymore, which is good news for insureds. And the second point, this is also good news for insureds, so basis clauses are also going to be abolished. So any provision in a prop form that tries to convert insured responses into contractually binding warranties is no longer going to be effective. And it's worth noting that this particular provision, so the provision relating to the abolition of basis clauses, can't be contracted out of by insurers or insurers. So in conclusion, I would say that the 2015 Act is a compromised Act. So it was put in place under the parliamentary fast-track procedure, and so it's only possible for uncontroversial legislation to be done in this way. So certain elements of the insurance bill had to be removed before it became binding legislation, and that's unfortunate. But I'd say that it's a positive thing overall. So it's a simple, short Act. It does provide for additional obligations, certainly on the part of insureds, so the disclosure obligations are more extensive, and insureds are going to have to get in place policies and procedures internally to make sure that they comply with those provisions. And also there are additional obligations on the part of insurers, so insurers are going to have to be very clear when they come to drafting policies of insurance, especially around exclusion clauses. But what I would say the main positive of the Insurance Act 2015 is that it provides much needed clarity around the obligations of both insurers and insureds, and gives, again, much needed clarity and detailed clarity in relation to the actual practical steps that parties have to take in order to satisfy their obligations to the insurer, if you're the insured, or to satisfy their obligations to the insured if you're the insurer. And one last point to note for the future, so damages for late payment or non-payment of claims, this is going to happen. So its most recent iteration is in the Enterprise Bill, which is going to become an Act possibly next year. So that regime is on its way. This is something that was cut out of the Insurance Act, but it is going to happen under a different guise in the Enterprise Act. And now, finally, just to round this off, I'm going to hand over to Stephen, who's going to talk us through D&O liabilities.
Thanks, John. Okay, I'm going to spend the last 10 minutes or so wrapping up today's talk with a few words about directors and officers' liability. Who owes these duties and what these duties are. Now, the starting point is to give a bit of context because directors are directors of limited liability companies, and it follows from that in 99% of the time their liability is limited. Directors don't have an obligation to reimburse the company's creditors, as neither do its shareholders. But the price to be paid for limited liability is directors have to attain a particular standard to protect the company, its shareholders, its creditors, and other stakeholders against the actions of rogues. So, who owes these duties? There are directors, as we all know them, called de jure directors, is the legal term. That's someone who is properly appointed by the board. The form is filed at Companies House, it's held out by the company as a director, and everyone knows that person is a director. But that's not the end of the story. There's another class of directors called de facto directors. That's someone who is held out by the company as a director, acts as if that person were a director, but the formalities haven't been complied with, the forms that haven't been filed at Companies House, and that person hasn't been validly appointed. Now, everything I'm going to say today just about applies equally to a de facto director. And finally, there's a class called shadow director. Now, as the name suggests, this is someone who operates in the background, pulling the strings of the company. It won't be formally appointed, it won't be held out as a director of the company, but in reality, the director is doing whatever that person tells the company is doing whatever that person tells the company to do. And if someone falls into the category of a shadow director, they pretty much become subject to all of the duties that a formal director is subject. So, what do directors have to do? Now, over time, a director's duties grew up by a body of case law, and we tend to refer to them as fiduciary duties because there's a relationship of trust between the director and the company. Under the Companies Act 2006, those duties have been codified and they're helpfully set out in one place so everyone knows what they are. And I put them on the slide here. They're pretty self-explanatory and in fairly plain English. To act within the company's powers, to promote the success of the company, to exercise independent judgment, to exercise reasonable care, skill and diligence. This duty has two elements, as often in the case in law. There's a subjective and objective part to this. All directors have to attain a reasonable standard, but if a director has particular skills, expertise or qualifications, those will be taken into account as well in determining whether the director lived up to the duty. Next one, to avoid conflicts of interest, not to accept benefits from third parties, and to declare an interest in proposed transactions. Although not part of the Companies Act duties, directors also owe a duty of confidentiality to their company. Now, the important thing to bear in mind is that these duties are owed by the directors to the company itself. They're not owed to the world at large, and if a creditor, for example, believes that a director has breached these duties, that creditor doesn't have a direct claim against the director. If something has gone wrong, a company can bring a claim against a director who has breached those duties. They will have a right to seek damages, perhaps to have injunctive relief put in place to stop something happening, or for the director to account for any profits that he or she has made as a result of the breach of duty. The shareholders, in theory, have a claim against the directors, but they can't bring that claim directly. Any claim has to be brought through the company, and the company acts in accordance with what the directors tell it to do, and often there'll be a situation where the directors will be reluctant to bring a claim against themselves effectively. So in those circumstances, the shareholders can get permission of the court to bring what's called a derivative claim through the company against the directors for the benefit of the company and indirectly for its shareholders. As I say, those duties are not owed to the world at large. Sometimes in class actions, possibly for reasons of publicity or to cause difficulty for individuals, the claimants will want to bring a claim against the director as well as the company. And if they do so, they will have to establish some separate cause of action outside the terms of the Companies Act. One example that I've been working on recently, it involved a claim that the directors acted in a legal conspiracy together with various companies to the disbenefit of the claimants. So moving on to when directors are faced with a situation where their company is running into financial trouble. And in those circumstances, the directors do owe duties to a wider class to the company's creditors. And when the company starts to run into trouble, they have to give proper regard to the interests of the company's creditors. And if they don't, they potentially leave themselves open to claims by the company's liquidator. And I mentioned two of these briefly, misfeasance and wrongful trading. Wrongful trading is when a company reaches a stage where there is no realistic prospect of avoiding insolvent liquidation, and from that point the directors don't do everything they reasonably can for the benefit of the company's creditors. In practice, this normally means continuing to trade when there's no real prospect of the company not going bust. If the directors are responsible for that, the liquidator may bring an action in wrongful trading, and if the liquidator succeeds, the court agrees with the liquidator, the directors can be ordered to contribute towards the company's losses, the additional losses that were incurred as a result of the company continuing to trade longer than it should have done. Misfeasance involves similar issues. I spoke a couple of minutes ago about the duties to which directors are subject under the Companies Act. And if a director has been in breach of those duties or other related duties and fallen well below the standard that a normal competent director should attain, the liquidator can bring a misfeasance claim against those directors. And again, if the court agrees with the liquidator, the directors can be ordered to contribute to the losses that the company has suffered. Now, again, I'll emphasise that these are not run-of-the-mill actions, and they are aimed at the real rogue directors. It will be a defence to a misfeasance claim to show that the director acted in good faith and made an innocent but honest mistake. It's also a defence in most cases to show that a director took and importantly acted upon a professional advice when he or she realised things were running into difficulties. Aligned to misfeasance and wrongful trading is a disqualification. Now, it's not so the director won't be ordered to contribute financially if convicted under disqualification action, but will be prevented from acting as a director for a period of between 2 and 15 years, depending on the severity of the breach. A couple of words about indemnity and insurance. This is a terminology point as much as anything. A company is not permitted to exempt its directors from breaches of duty, and if it attempts to do so, that exemption will be void. A company in limited circumstances can give an indemnity to its directors against certain breaches. However, the indemnity is only worth as much as the company itself, and of course if the company goes bust, then it's little comfort to a director to have a theoretical but worthless claim under indemnity against the company. Now, to plug these gaps, directors will often take out what's called D&O insurance, directors and officers insurance, and that involves many of the themes that Victoria touched upon earlier. So to wrap up before we get to questions, just a couple of points from my practice and bringing and defending these claims for many years. By far the most important message I could give to anyone who may ever find themselves in such a situation is the importance of record keeping. Now, it sounds obvious, but it doesn't always happen in practice. It could be as much as 10 years after the relevant event that the conduct gets tested in court. That's because there's a 6-year limitation period starting from commencement of the insolvency, and cases that take a while to get to court anyway. By that time, memories are long since faded. So it's very, very helpful if the reason why a particular decision was taken is properly documented and recorded in the minutes of the company's board. And that's especially important for small companies that typically exist with less formality than would be the case for larger organisations. And secondly, I'll mention is the importance of taking professional advice. This isn't particularly intended as a sales pitch, but it's often something that will be taken into account by the court when considering claims such as this. Particularly for misfeasance claims, it is a recognised defence that the company's directors sought advice and acted upon it, even if they ran into difficulties notwithstanding.
Okay, great. So we've had a couple of questions, and a question to John is, could my insurance cover be subject to the two regimes as a result of the Insurance Act 2015?
Okay, yeah, I think that's a really interesting one. So as I mentioned in my slides, so the Insurance Act is very much not retrospective, so it applies to only insurance contracts on or after the 12th of August 2016. It also applies to variations to insurance contracts on or after that date. So I suppose in theory, if you had an insurance contract that predated the 12th of August and then you subsequently varied that after the 12th of August, you could potentially have different provisions within your contract of insurance that are subject to different regimes. I suppose the answer to the question really depends upon how substantial the variation is, and I suppose also practically, if you're an insurer or an insured, you probably wouldn't want to have two different regimes applying to various different bits of your insurance relationship. So I think it would probably be sensible in practice for insurers and insureds to agree that if there is a variation after the 12th of August relating to a pre-existing contract of insurance, then that is subject to the new regime, bearing in mind that there are some bits of the new regime that you simply can't contract out of.
Okay, great. Thanks, John. And a quick question to Stephen is, are class actions covered by D&O insurance?
Yes, so with any insurance policy, the exact risk that is covered will be up for negotiation, but this is something you would expect to find within the D&O insurance policy. Class actions can be brought by a variety of claimants, though something we're seeing a rise in at the moment is class actions by shareholders claiming against the directors of the company for breaches of the sorts of duties we've been talking about today.
Okay, thank you. I think that's all that we've got time for today, but as John said earlier, we will follow up any further questions you may have with you directly, so just send us an email.
Brilliant. Thank you for joining us.